this Wednesday, August 25th, 2021. Roll call, please.
Director Ariki?
Here.
Director Urosic?
Here.
Director Chisholm?
Here.
Director Recca?
Here.
And Director McLaren?
Here.
Recording in progress.
All right. We will go to the adoption of the agenda. Do I hear a motion to adopt the agenda?
This is Derek. This is Derek. I'll make a motion.
And I'll second it. This is Director Recca.
Okay, we have a motion and second. Can we have a roll call vote, please?
Director Ariki?
Yes.
Director Urosic?
Yes.
Director Recca?
Yes.
Director Chisholm?
Yes.
Director McLaren?
Yes. Next, we'll move to 4, which is public comments for non-agenda items. This portion of the agenda allows an individual the opportunity to address the board on any item regarding Watermaster business that is not on the agenda. Do I have any public comments at this time? Okay, once again, any public comments? Okay, hearing none, we will go to 5, which is the workshop presentation. And this will be done with the general counsel and staff presentation of Watermaster Enforcement activity.
Yes, thank you, Chair. This is Craig Parton, General Counsel for the Watermaster. Just as a reminder of how this was created, this workshop, and the incentive to do it, we at the last board meeting were directed to have a workshop on the general topic of enforcement, what our policies are, what the issues are, and get some specifics as to steps going forward to improve the enforcement activities. So the outline for this morning, which will be a joint effort with the Watermaster engineer staff, with Watermaster staff, and with General Counsel, depending on the issue. And really the staff are the, as everyone I hope knows by now, are the front lines of this issue of enforcement, and really have the practical experience with how compliance becomes an issue, and how we might better deal with the enforcement questions that we have. Let me also say that I think in general, people are acting good faith and meet their obligations under the judgment and the physical solution, but we do have those that don't. And while we have not specifically identified them in this workshop, staff is very firm in their interest in a future workshop where we can talk about individual situations that have become enforcement problems and how to prioritize those. So the outline for this morning is there at slide 2. We'll have a discussion about annual production reports and how important those are, that we have those, and their connection to an effective assessment program. These are all linked together, as is meter compliance. Without meter compliance, we have inaccurate production reports. With inaccurate production reports, we have difficulty doing accurate administrative assessments and replacement water assessments. So there's a connection between numbers 1, 2, and 3. Then at point 4, we'll have a discussion about how we handle those who are producing water in this adjudicated area who have no production right to do so. And also the subject number 5, pumping in excess of production right, which has been a topic addressed by the board and by recent regulations that have been adopted and approved by the court. And finally, we'll talk about next steps and get input and feedback from those on the call. So we'll start with number 1, the outstanding annual production reports. I believe this is going to be a joint effort of staff and the engineer, but I'll kick it over to Phyllis to start with.
Thank you, Craig. Good morning. It's Phyllis Stannon with Todd Groundwater, serving as Watermaster Engineer. I do want to just very briefly go over items 1 through 3. It seems that when we get to item 4, that really is the topic that I think most people are concerned about. But with respect to the annual production reports, I have just a couple slides. On item number 2, I just want to say that I don't have any slides on that, but we are continuing to provide the AR summaries in all of the board packets. So every week, the board and the public have the opportunity to take a look at any past dues for administrative assessments and replacement water assessments. And in particular, staff wanted me to also point out that there is a penalty, a percentage penalty on those assessments for late payments. So that is being handled. I think we have coverage in the rules and regulations on how best to handle that. So I think that's going forward as is. So I'm just going to say a couple of things about items number 1 and items number 3, and a big shout out to staff for putting a lot of this stuff together for us. So moving now to the outstanding annual production reports. As Craig said, this is really key. I feel especially compelled to try to make this effort be 100% compliant. The Watermaster Engineer's primary responsibility under the judgment is monitoring of safe yield components. And this is a biggie. This is the largest outflow from your groundwater basin. And if we can get this right, our water budget estimates going forward will be a whole lot better. We had pretty good compliance overall, let's say, for the Exhibit 4 producers, about 88%. There's maybe 17 or so producers that did not turn in their 2020 annual report. 100% of the Exhibit 3 producers. We always have trouble with the state of California. They have 9 separate rights under the judgment, and it isn't even clear to us, I think, or them necessarily, that they have wells pumping in the subbasin. We do know of a couple. We do get a little bit of compliance from them, but we really have nowhere to go with the state. Staff has contacted their trial attorney that was associated with the original judgment, but that person is now gone, and the other person that is replacing that person doesn't know anything. So trying to get state of California to comply is always a challenge. Almost all of our supporting landowners, the non-stipulating parties, have reported. I think there's one outstanding there, but it's not associated with very much production. So a couple of things. Even if we have these high percentage of compliances, and even if the missing production reports don't amount to a lot of water per se, not getting them in time for the 2020 annual report it is problematic, because then that production doesn't get memorialized. We try to kind of go back, and our annual report is continually trying to show past years where we are more and more compliant, and that is a direct response to staff's efforts to just continue to hound these people and say, where is your 2017? Where's your 2018? And so we're getting there, but not having them in time for the report is problematic for this basin, I think. So we not only want full compliance, we want full compliance on time. Producers are given until March 1st to submit their report, and so we feel like that's a reasonable amount of time to get this in. I'm always asked how much water does this represent? If we took all of the missing reports, some of them have 0 acre-feet a year production right. Many of them have 1 acre-feet a year production right. So it doesn't amount to a lot of water. Our best estimate for all of these missing reports is somewhere around 3,300 acre-feet a year. And so that, it's not a huge percentage of the native safe yield of 82,300, maybe 3 or 4% or so missing. So again, not a lot of water, but, not 0 either. And then if I can go to the next slide, staff has already, taken actions. This is not as if we're just sitting around whining about how we don't have these reports in on time. I mean, staff makes monthly calls. They have constant emails. They have actually written delinquent letters to the producers each year saying, we don't have your reports and you're in violation of the judgment. They provide the producers with the reporting forms to make it easy for them. And they also, if there's forms outstanding from previous years, they send them those forms as well and say, please fill out, 2018, we still don't have it. Please fill out 2019, we still don't have it. And then obviously they're still doing research on contact information. There's about 7 or so parties that are just completely non-responsive. They're Exhibit 4 parties. They're on the judgment. They do have a production right. It's not very big typically, but it's relatively large. And so again, what can staff do when we write letters and they make calls and they make emails and they send forms? So we really are looking for some guidance on, this process. So that's all I'll say about the annual production reports. And we'll just move now to another topic of concern of the Watermaster engineer in particular, and that's compliance with installation of well meters. When we first started looking at these numbers, we were talking about numbers of parties that were out of compliance, mainly because we didn't have a good estimate on the number of wells that everyone had. We do require on our annual production reports that they provide us with production by well, and we have some additional and better information. It's improving over time. I think over the last 5 years, we've gone from knowing very little to knowing quite a bit about the 460 some wells that are active in this basin, and staff has compiled a list of that. So now we are thinking and looking at the compliance for meter installation as a percentage of wells that have been documented rather than parties. And this really has, it's made our percentages go down a little bit with respect to the number of compliance because we don't have compliance for every single well. But we are, again, pushing on that. You can see the numbers there of the documents submitted for the number of possible wells. Again, possible. We don't field check this. We couldn't possibly go out and look at 468 wells and see if they're all plumbed and equipped. But overall, we have for the Exhibit 4 producers, about 86% of those wells are have been documented as metered. The Exhibit 3 parties were primarily metering anyway, so that percentage, of course, is higher there. And then the low 31% there is primarily associated, again, with the state of California and their production rights. So, again, just as with the annual production report, staff is continuing to push on what to do when parties don't have compliance. And as a result of that, they are continually adding to their list of wells. It's really great to be able to begin to have a good list of the existing wells in the basin, and obviously they track new wells also. They have done research in terms of trying to contact, again, these 7 parties or so that they just simply can't get anyone to call them back or respond at all. They've had multiple notices. And in particular, Craig wrote a letter informing these parties that they weren't complying and that they had to comply. And then there's been numerous follow-up phone calls and emails, etc. So I don't want the board to feel like that staff and the Watermaster engineer are ignoring these issues, far from it. But at this point, we really want to think about, process and some way to put some teeth into these numerous calls and numerous actions that staff has been having to take. And so with that, I'm going to turn this back over to staff to pick up on some of the additional enforcement issues that we're dealing with.
Thank you, Phyllis. This is Angel Fitzpatrick with the Watermaster staff, and Watermaster staff wanted to share some of the ways that we identify producers that are pumping with no production rights. One way that we identify these producers is the default list. The default list is a list of parties that defaulted in the judgment, and this list can be found on Exhibit 1 of the judgment. Defaulted parties have no right to produce groundwater from the basin and were not issued a production right. We also receive tips and complaints. Watermaster staff receives telephone calls and letters providing tips and complaints regarding pumping within the basin. The County of Los Angeles has been a huge help to the Watermaster with implementing the judgment. Before the county issues a well permit, LA County Environmental Health requires a Watermaster approved well application, such as a new production application, a replacement well application, or a new point of extraction application. This process helps regulate and identify production in the basin. An example of this is recently a mobile home park filed for a permit to drill an additional well. And because the county does require an approved well application, this mobile home park had to reach out to the Watermaster. After staff researched this mobile home park, we discovered that this mobile home park is a non-party to the judgment and has no right to pump the groundwater. Another way producers with no production rights are identified is by the State Resource Control Board. As most of you are aware, the Watermaster did write a letter to Lahontan Water Board in June 2020, requesting their assistance in meeting the judgment requirements for groundwater quality in the Antelope Valley. We also asked to be added to their general mailing list. As a result, multiple wells and producers have been identified. And last, aerial maps. Watermaster uses aerial maps to identify properties, and aerial maps can also be used to monitor the small comfort class numbers. And with that, we can go ahead and move on to Craig.
Yes. Angel mentioned the issue of people pumping in excess of their production right, or actually pumping with no production right, which is a more serious situation. And we just wanted to provide to you the outline of where the judgment and the rules and regulations, even as recently amended as last month, speak to these categories of people. Those with no production rights are defaulted parties and non-parties, and they need to pay replacement water assessment. This is just a way of reminder for all post-judgment production, and non-parties need to intervene. We've had a number of motions for intervention by those operating in good faith who want a production right in the basin, who want to apply for new production and pay replacement water assessments in good faith, and have done so. But we have people that are not parties to the judgment that are taking water from the basin that need to be subject to a motion to intervene, followed by an application for new production and payment of replacement water assessment. So we have the defaulted parties and non-parties with no production rights, and then we have the subject that we've dealt with at the board level for a number of months recently, those with new production right applications and who may be in the process of exceeding their allocation under their new production right. Assessment is the cost of doing business. We've recognized that, the board has recognized that as an issue, and as a result, the rules and regulations have been amended significantly in the last couple of months to apply a stringent purpose and place of use requirement for the use of the production right, and increasing penalties for parties that exceed their production right, even allowing the Watermaster to revoke their new production right if there's an abuse of the approved amount, purpose, and place of use restrictions that are in the rules and regulations. So in structure-wise, we feel comfortable that we have the means to enforce people that take advantage of their new production right and exceed it as a cost of doing business, that are now under the real legal consequence of having their new production right revoked if that is engaged in for more than a year in succession. Can we go to the next slide? I just want to remind everybody of what the legal remedies are that have been pumped up in the rules and regulations that have been amended and approved by the court. Just a reminder that the Watermaster can seek full monetary relief. We've done this before, and we're doing it again and in the process of doing it now to parties that are either producing in excess of their production right or have no production right and are pumping water in violation of the judgment. We bring notice motions. We did this recently and are considering doing it again in a couple of cases. We are very well aware of the parties that have not been cooperating in producing meter information or production reports. This all goes together. If we don't have meter compliance, we don't have accurate production reports, we can't accurately know the amount of assessment that's appropriate for that party. And now we have in the rules and regulations in section 19 the authority to recover our fees and costs in efforts to remedy the failure to meter and report production. And so we are confident that we've got the tools necessary now to enforce and receive recovery of our fees and costs when we're required to do so under the judgment. And that last comment, enforcement of a money judgment is an enforcement action, can be recorded as an enforceable lien against a party's real property. Can we go to the next slide?
Greg, I have a question, Mr. Wayne.
Yeah.
In the last slide on the item where you talked, the top one there on the law and motion procedure, when you seek relief, is it possible to get a suspension or a temporary suspension of water rights?
Yes.
Necessary.
It would be a temporary injunction against the exercise of any pumping activities on the property, and that's exactly what we're going for.
Okay. All right.
Yeah. Yes. This is just a reminder here of the new rules and regulations section 19H that the Watermaster staff and engineer have that authority now to require when the principle is if somebody comes asking for something from the water master, we have the ability and indeed the obligation now to make sure that they are in compliance with reporting, metering, payment of assessments prior to adopting any resolution that approves what they want to get from the water master. Talking with staff, and they've expressed considerable concern about the delays in enforcing provisions of the judgment, the rules and regulations, that we not send the message that we won't be coming for you if you don't take seriously the production report, the metering, the payment of past assessments, intervention into the judgment if you're a non-party, and the other rules and regulations. So we left this for discussion and possible agenda item for the board for next month. It would be helpful, I think we're in uniform agreement with staff on this, that there needs to be some specific process, and we say here timetable, for when the enforcement issue rises to the level of it comes to the general counsel for enforcement and approval by the board for that enforcement action. And one suggested thought was creating a subcommittee of the board, as we've done with the administrative subcommittee, that will meet regularly and bring recommendations to the board about prioritization. It's always a tricky business about who is the priority matter that we need to focus on. But the thought was get some process developed, some specifics developed in terms of how enforcement will be applied, and take out the uncertainty for the staff of how long and how many times they need to write letters requesting production reports before we take action. So with that, open it back to the board for discussion, comment, questions from the public on how best to proceed going forward.
Craig, this is Adam. Can you guys hear me?
Yes, perfectly.
So I have a bunch of comments, questions, and so on and so forth. To me, the way to get people's attention is to have them in their pocket somehow. One way we can consider, maybe through this, whether it's the admin committee or a new ad hoc committee, is something similar to what is being used in other adjudicated basins, and that is to back calculate or estimate the amount of water that potentially pumped using electrical power. And I've proposed this several times. Now, it would take us asking Edison to provide the electrical usage. And I don't know how the legal authority, given all the areas of the judgment we've cited that the Watermaster Board has, if we could ask for that information, and that information can be provided easily to us. I imagine that there is a way to get that information. We can even ask the property owner to provide that information, and then back calculate or estimate the amount of water that could have been pumped. Now, granted, you would need to have something called well efficiency test, which Edison does. Essentially, what that test does, it estimates how many kilowatt hours that particular well uses for every 1 acre foot of water pumped. But if we can get that information timely for the annual report or by March of that particular year, we can always assume the efficiency is 50%, which is in the ballpark for those wells, probably low. And then just use the kilowatt hours to back calculate how much water is pumped. Now, people can complain, and we say, well, the other alternative is for you to install a meter. So that's one way that we could deal with that. The other thing, you've said that the judgment does allow the watermaster to take actions, injunction and other actions, is for us to send one letter, second notice, and then the third notice is, okay, this is your warning, and we are going to take legal action against you when we're going to seek injunction from pumping. And then we literally stop these people from pumping, and that will get their attention as well.
Yeah.
So things of that nature, I think, could work. They're harsh, but I think we've been at it now for 5 years, more than 5 years. And by now, people have refused to install meters. They've refused to import their productions. The only thing I can think of is they don't want to comply, period. And then if they don't want to comply, the watermaster, and we can always charge them for all this time that we're going to spend seeking innocent records or filing motions with the court. All this cost based on the rules and regulations of the watermaster can be recovered. And that will also get their attention. Now, instead of looking at a $2,000 bill for overpumping, they're going to be looking at more like $5,000 or $6,000 bill. And then I have a question for you, and I will leave it for the other board member to ask questions or comments. Does the board have the authority to actually hire someone to go and install a meter on somebody's well and charge them, of course, for that meter?
I believe so. The board has the authority to hire consultants, etc., under the judgment. I'd have to look at the specific section, but I know there's a section that deals with the retention of consultants to further the goals and abilities of the watermaster.
And we're going to be entering private property.
Right. No, I understand, but we want to start with getting an injunction against further production and a requirement that a meter be installed and no more production occur until production reports are current and the meter is installed. Otherwise, they can talk to you about violating the court order to the judge.
Okay. All right. But those are the three things that I see as ways to deal with this issue, and they are not really that difficult to implement, particularly in light of the fact that we can recover costs associated with their implementations.
Yeah.
Thank you.
This is the way, following up on that conversation that Adam talked about. Craig, what type of authority or means do we have for collection of whatever these charges are? In other words, can we assess the property taxes, or in other words, is there a method, a legal method in which we can, put a lien on a property or something like that in order to be able to collect these delinquent fees?
Yes, we referred to that in the slide number 9 about the possibility of an enforcement action with a lien on person's real property. The judgment in the rules and regulations give the authority to do that and collect a money judgment in any way that needs to occur. Normally, people, when there's finally a judgment for a money amount, you work out a payment system because the enforcement action has got its own costs and time and defenses and other things that occur. But we can, to the full extent of the law, enforce a money judgment any which way we can.
So in essence, ultimately, we can get the money from the violator. It may take a long time to do that, but certainly we have that remedy that allows us to be able to recover the cost.
Right.
Thank you.
Mm-hmm. And this is Adam. I'm assuming that similar to Opinion Hills and others, these outstanding balances, they accumulate interest, correct?
Yes.
Thanks.
I guess this Dwayne Chisholm again. I guess it's the administrator in me here coming out, but it seems to me as if we should have a plan or kind of a schedule that occurs every year that we would once the March deadline comes and we go through the normal notification process. Maybe it's one call, one letter, second letter, third. But I think you kind of we have to decide: are we going to go to court on all of these and just bundle them all up? You know, it's not a significant percentage of the total water, but there's quite a few people here that have just decided not to comply, and bundle them up on a yearly basis, get the injunctive relief and go through that process. And I think those violators, especially for the 1, 2, 3 items that we're talking about, will probably come into compliance fairly quickly. And then if you have some rogue person, as we go out into the years before, we'll at least have a process that we've developed so that we don't let these go past a year's time frame.
Mm-hmm. Doing kind of trigger this is Adam, trigger my mind of a question I wanted to ask fellas, but maybe Craig or the staff know this too. Are these the same people, or in other words, the people that do not report? I understand the people that haven't installed meters probably are the same, but the ones that don't report, they don't report every year, or do they report every other year, or whatever they feel like it, or how?
We do have, I'm sorry, please go ahead, someone.
Some of these are repeat offenders, Adam, but we also have to keep in mind that some of what we are talking about in this discussion is the people that are not in the judgment, people that we are finding that have wells that we need to get new production applications for, that we need to identify them. And so they're not on Exhibit 3 or Exhibit 4. They're not a small number. They're ones that we're finding. So
okay. Either defaulted or not.
We do have some non-reporters that are repeat offenders. They have not reported since, the judgments went into effect.
Okay.
But so we're really kind of talking about two different groups here.
Okay.
Go ahead, Phyllis. I'm sorry.
No problem. That was an excellent answer. I was just going to point out that there are some again repeat offenders. There are, and again, I just want to point out there's 6 or 7 parties or so that the Watermaster staff has never even talked to. They can't get anybody to respond. Most of those are 1 acre foot a year, probably not producing, maybe not in the valley anymore. But it changes from year to year and time to time. I mean, sometimes people are just late, and we get that. But this year, for example, and I know we're not trying not to name names here, but we have one party that's probably 61% of the total amount of water that we're missing this year. And they've been responsive in the past, and now all of a sudden they're just not taking calls. There's no way to get in touch with them. So, sometimes people just disappear, and we're wasting a lot of time, I think, trying to find them. And so there's that issue as well.
And that's really a question of, and why I think it would be beneficial for the board to discuss agendizing it for next month at the subcommittee and get some specifics on prioritization. because absent bundling, as Director Chisholm mentioned, which we can do to save legal costs, we want resources to get the major result that we can get. And Phyllis has pointed out one party that's responsible for 61% of the unaccounted for water. That is, to me, an issue of prioritization, and we can get on the same page with the board at the subcommittee level and get moving on this with specific recommendations and process. I think it would be very beneficial.
One of the comments that I just want to make, and then I'm not going to say any, I always say this and everybody laughs, I'm not going to say anything else. Meeting after meeting after meeting, we all talk about the new producers and how much they're producing. An applicant might come in and want 12 acre feet of water. And, we really look at that application and we really drag that over the coals. Those are the people that are trying to comply. They're trying to do it on the up and up. We have so many producers out there that we have identified and we have not done anything with them. Some of them are pumping 100 acre feet a year or more. And these are the producers that we really need to start paying attention to if we want to manage our groundwater basin and bring them into compliance. They're the ones that are basically pumping for free. And these are the ones that I think that we need to really start putting our attention to.
Craig, can I make a comment?
Yes, please.
This is Julie Kyle. I just wanted to piggyback on what Adam brought up. His first statement in bringing people to enforcement was, if you get into their pockets, that should help. Going off of that, for all of us who report to the State Water Resource Control Board and have for decades, several years ago, they were having issues with people reporting, and just like what would happen with Phyllis, if she can't have accurate numbers, neither could the state get accurate numbers. So they came out with a statement that they put out on their paperwork that they send out about 90 days in advance of when you even need to start reporting, that says failure to file a statement may subject you to civil liabilities that carry a maximum fine of $1,000 plus $500 each day for the violation continuing after 30 days, which would be, you'd be adding up some money in a hurry. And we completely agree with Adam. If it doesn't hurt them financially, people just appear to just blow us off. Thank you.
Thank you, Julie, for the comments, and we recognize the fact that the pocketbook is the way to change behavior.
But can a statement of that type be included in our letters to these people or our notices, or do we have a legal authority to include such a statement?
We're not statutorily authorized to impose fines in that manner, but then again, we have a lot of arrows in the quiver still with respect to recovering costs, attorney's fees. That gets the attention of people when they're looking at an attorney's fee bill of significant magnitude.
Mm-hmm. Do we include that language in our letter to them? Do we say that if you don't comply, then we have to
yes, recover costs? Yes.
Okay.
Yeah.
And then interest and all that stuff.
The interest component, I'd have to check with staff on whether we mentioned that.
Mm-hmm.
But we certainly talked about cost recovery.
Mm-hmm. One question for the staff. Have we ever sent a bill to these people instead of a letter with an estimated pumping, and let's say a non-pumper or a defaulted party that has no water rights? Have we ever sent them a bill saying, we estimated that you pump 10 acre feet and your bill is $7,000?
No, we've never done that. We have one that we are waiting to intervene, and we have discussed whether we should send them an invoice, and it has come down to that they're not in the judgment yet, so we really may not have the authority to invoice them since they are not in the judgment. We don't send an invoice until we have some type of report to send off of.
Report of production, right?
Right. Now, we have discussed when we were doing this enforcement presentation, we talked about whether when we identify somebody as pumping outside of the judgment, should we get Edison records right at that point and not wait for them to report? And then say, then go to them and say, we understand that you're pumping this much water. That's a lot more work for staff, and that's something that if we had an enforcement committee, they could help give direction, and that would be part of our process. I don't know that we feel comfortable doing that yet without having board approval to do that, and without having a written process in place. We don't want to overstep our boundaries, and we don't want to, that's really kind of a board. That's a tool for the board to come up with.
No, that's good to know. Thanks, Patty. I really appreciate that. Because I think I get it. I'm sure it would create additional work on the staff. But to me, if we are, as I understand, if we have the ability to recover this cost, even if we have to hire a consultant to do this work for us, and have them do it, and then we'll recover the cost from those people that are they're not compliant. Bottom line, it's going to get their attention, and sooner or later, they're going to comply, because it will be otherwise they would have to be paying a lot more money than otherwise they would have if they had a meter and they're reporting their productions. Because we're going to estimate it. Maybe their well efficiency is 70%, but we're using 50 or 40. Depends on how old is the well. And all of a sudden, they're paying a lot more money than if they just comply with the reporting. So, but I agree with you. I think that decision needs to be done by the board, and maybe the committee that will form will discuss those options and bring them to the board for approval.
Yeah, this is Derek. I'd just like to comment that I truly support creating an ad hoc that can work with staff to help direct them, outside of these board meetings in a more productive process and more timely process, and prioritize, who, how, and, who and how we should be attacking this and get things rolling, because I think we just struggle talking through these things at the board meeting, and we keep losing time on it. So I fully support, getting that started as soon as possible, and, presenting back to the board those recommendations and start putting it to work.
Amen.
Great. That'd be excellent, Derek. If that can be initiated at the board meeting to be an agenda item for next month, that'd be great. I don't think we have Phyllis, Patty, Angel, any further comments?
I'll just point out that we do have on our chat room a comment from the public that I thought was worth bringing up. We've talked about people who are pumping outside the judgment and people who have a right versus not have a right. One of the things that has been brought up in the past by many of our producers, and again by the public today, is the concern that some of the parties who have a right to produce from their well are actually producing from their well and selling some of that water for a variety of purposes. I know that cannabis and illegal activities have been a big concern, but even if it's for some reasonable use, I wonder if there's something that we can do to make sure our parties know that they're not allowed to use their water for beneficial uses other than for what they're intended. And so I don't the sale of water from people's wells who have a right to produce, but they're actually selling the water to someone else for some other beneficial use. So that was just one nuance that I just wanted to get on the list of things that our growers and our public have a concern about.
We have a place of use emphasis in the new rules and regs 14N that tries to address that post so that the material injury analysis on a new production application looks at where the place of use is, and if that is not honored, and particularly it's obvious if it's exported out of the basin, but even if it's exported in some way beyond where the place of use is in the application that's approved, those are grounds for revocation of the application of the permission that had been granted.
Right, and so we just might want to have some sort of it's a minor point compared to those who are producing that we don't really even know they're producing, but it's just a nuance that just shows that there's a lot of creative things that we'd like to be able to address.
And again, I don't know if this will apply to non-potable water, but for potable water, you're not supposed to sell potable water or put it in a truck unless you get the state FDA, Food and Drug Administration, I guess, permit. You can just go and get a truck and fill it up with water and haul it whatever you feel like. Right. So I know that doesn't apply to some people for whatever reason, but that's another hook that we could use as well.
Yeah. Okay, if, any final comments? We've got the board meeting in 5 minutes, which by the way, are we supposed to leave this meeting and rejoin or just stay on?
You can just stay on the line.
Okay.
Yeah, I think it's an agenda item in the board meeting, this workshop.
No, it's a separate, this is a separate agenda, but we will put as an item in the next meeting, we can put on there that we want the enforcement issue to be on agenda-sized at the regular meeting in September.
Patty, could I ask a question?
Sure.
Craig, this is Galen, Kyle. I was curious if you can bundle a group of abusers together and go to court with a group instead of having to do it individually.
Yeah, Galen, we haven't attempted to bundle it. It presents its own problems, but for cost efficiency reasons, it may be worth looking as long as it isn't taking away the due process that the party is entitled to. I think we can do it seriatim in a bundled process. But the real question is that there's some major players that are need to be focused on initially, and I think those major violators of the judgment need to be taken up one at a time.
Well, I'm all for working on anything that we can do to bring these people into compliance. So, but with that, do we have any other comments, or can we adjourn? Can I get a motion to adjourn?
I move that we adjourn if there is a need to adjourn. I thought I understood that we can continue.
No, we're going to adjourn this meeting, but you can just stay on the line for the
Got
next.
it.
You don't have to hang up and call back in.
All right. In that case, then I move that we adjourn the workshop meeting.
This is Derek. I'll second.
Okay, I have a motion and a second. Roll call vote, please.
Director Ariki,
Yes.
Director Recca,
Yes.
Director Urosic,
Yes.
Director Chisholm,
Yes.
and Director McLaren.
Yes, so we are adjourning to our next meeting, which we tried to start at 10
So,
a.m.
yeah, we'll be quiet for about 2 minutes, guys.
Yes.